This officer wanted to check if the driver was drunk. However, when a second officer arrived and tried to defend the citizen, the first officer got triggered and abandoned his own traffic stop.
I mean, if he don't want to blow into it, you know, he don't have to, you know that? I mean, it's not against the law to have a beer and drive, you know what I'm saying?
Yeah, we got to see if he can drive.
And how can you prove that? I mean, I have the most training right now. So
What are you talking about?
I'm telling.
Okay, well, here
All
you
I know
go.
is that man ain't gonna drive off and deal with it. Come on.
All right, how much you had to drink that?
I had one beer today, and that's it.
Right now, I mean, you're looking functional to me. I don't see nothing. I didn't even stop you.
Bottom line is, we just want you to blow in this. That way we can see if you able to drive.
The thing, Brown, is
I'm not gonna do that. I wouldn't
Okay.
swerve it.
Hey, Sergeant Brown, I gotta prove that he's less safe. I'll violate his Fifth Amendment right.
No, he was proved less safe when he was crossing that line
and now
down there.
What crossing what line? I did not.
he doesn't want to blow on it. That's his choice. When I make my DUI, I visibly see abnormal behaviors.
We're not gonna argue with each other in front of people. We're here to back one another up, okay?
Okay, and Joey left.
Now it's me and you here.
Okay.
So we're gonna do what's got to be done.
So what do you want me to do?
He don't want to blow on that, that's fine. But he's not driving that car away from here.
I can't be part of that because that's unlawful.
Do what you're gonna do. I'll take
Welcome
care.
back, everybody. Let's just forego the normal intro. I just want to get straight into this. So, there's a lot to dissect here, and I've tried to make this video a couple times now, and so there's a lot to dissect here, and I really just want to get to the case law perspectives because I know that you guys come and watch for that. But you know, and you guys know I'm a police trainer instructor. I teach advanced criminal investigative courses. I teach a DUI enforcement course, and what makes my training and my insight different than anybody else out there, nationwide, anybody else out there, is that I like to focus on science. I like to focus on case law. I like to focus about the truth of situations. And you may think that's a common thing, but it's not. And so there's so much to dissect here. Let me just call it out as I see it. I applaud the officer that's standing up for his beliefs and his ethics and the Constitution. He says numerous times that, you know, this gentleman does not have to subject himself to a portable breath test, a PBT. And he's 100% correct. You don't have to subject yourself to a PBT. You don't have to subject yourself to a standardized field sobriety test. You don't have to subject yourself to any of those things. It's a complete misnomer. You don't have to do the job, the investigative job of law enforcement. You don't have to do it. That's just one. Now, a lot of cops are going to hear that, and they're going to be upset with what I have to say, and that's fine, because I have never had somebody's lack of compliance ever impede my ability to conduct investigations. Now, sometimes it doesn't make it easy, but that's why I hit the book so hard. That's why I know this stuff from memory, because you're not going to stop me. Your lack of compliance is completely irrelevant to my ability to do my job, and I don't care. But that's how I live my life. I'm not a victim. Your lack of compliance is of no consequence to me. And a lot of people don't like that. That scares a lot of people, because I'm going to educate myself to a standard where your compliance is not needed. And so I wish more people took the job seriously, but that's where we find ourselves. So I applaud this officer who is taking the initiative to defend the Constitution, to defend rights, and defend his moral, ethical frame. To the other officer, the younger officer, the white officer, you're throwing a tantrum. He's literally throwing a temper tantrum, and completely unprofessional in this regard. I don't know him. I don't know all the events leading up, but I know a temper tantrum when I see it, and that's what he's doing. Plain and simple. It is what it is. I don't really care what his opinion on that matter is. And then for the older gentleman, who's the sergeant, just poor leadership. You know, at the end of the day, you're a sworn police officer like the other two gentlemen that are there. So if you want to have a portable breath test done, you can do it yourself. And if you're not qualified to do it, maybe we need to stop what we're doing, and maybe you need to really think about what it is that your role is and what you should be doing on the street. Because there's two reasons why he wouldn't do it himself. Number one, he's not trained to do it, which is a problem. And number two, he thinks because he's a supervisor, he's above police work, which is a problem. It is what it is. I'll call it out. I don't care. I don't work for them. And so when we look at this, from Illinois v. Gates, totality of circumstances predicament, we see that it's very clear what the sergeant's trying to do, right? He observed driving behavior, allegedly, right? I'll take him for his word. Driver failing to maintain lane. When he was talking with the driver admitted to having one beer singularly. Whether that's true or not, we don't know. And then based upon that evidence, he wants a portable breath test done because assumingly he's going to do the breath test. And if that breath test shows a result that he's willing to arrest on, he will. And if not, he's probably going to try to figure out a way, like he's saying, regardless, to have somebody else drive and not that driver. And so this is really scary because, yes, this could absolutely be a situation where you're violating somebody's rights unconstitutionally. And I believe that this younger officer has a moral frame, ethical frame, and has training experience that would lead him to believe that that's not okay. And the fact that he's willing to stand up to a sergeant, I can do nothing but applaud. So with that being said, let's just look at the case law, and let me just give you my quick. Again, I'm literally going to show you 4 slides of a 12-hour course, so we're not even scratching the surface. We're not even reading the intro. We're just going to use what we have just quickly for this video. Okay. So, based upon my training experience, I believe that utilizing, number 1, peer-reviewed medical indications, behavioral indications, psychomotor indications, psychological indications, and my training experience, coupled with a blood analysis report, is a better investigative and adjudication standard than SFSTs coupled with the Intoxilizer 8000, or whatever state Intoxilizer that is used for a breath test. And I say this because many states nationwide don't take the weight of SFSTs in a breath test with much merit. And we're seeing more and more case law showing that courts just really don't care about SFSTs. They really don't care about breath tests. It is what it is. So since we're kind of the PBT, the portable breath test seems to be the nexus here. Let's look at what we got. So you have that. Let's talk about PBTs. As you can see right here on your screen, many courts have affirmed that PBTs, portable breath tests, are not reliable. Generally, a roadside portable breath test indicates the presence of alcohol based upon a breath sample. It is designed for use by police officers to assist them in determining whether they have probable cause. PBTs are not subject to the same Department of Health regulations that govern breath analysis tests performed by state-approved machines. And so there's many case laws out there from many different states, to include the state of Oklahoma, that affirms that PBTs are not going to be admissible in court, especially admissible as a science-based, reliable, into determining whether or not, yes, in fact, you are DUI. That alone is going to do absolutely, it's not going to hold much weight at all. In fact, it holds such little weight based upon the case law, I don't use it. I don't even, when I was on the road, I wouldn't even put one in my car. It's of no consequence to me. I don't need it. I mean, that's how little I think of portable breath tests. And we're gonna get kind of more into it because, okay, we get they're not state approved. We get that the courts have said that they're not reliable, but they can be used to assist, right? They can be used in assisting roadside probable cause determinations, according to the courts. Well, let's take a look. I'm in the state of Oklahoma, so let's look at Oklahoma real quick. And there's many other states that have similar state case law, but here in the state of Oklahoma, I'm not even going to pretend to pronounce that, Moratori versus State of Oklahoma 2014. Again, the Oklahoma Supreme Court showed that there was issues with the admissibility of a breathalyzer test, and ultimately, based upon the unreliability and the certificate analysis for the gas canister that was used in the Intoxilizer 8000, that they were admissible hearsay. And that's coming straight from the United States Supreme Court. So the Oklahoma Supreme Court. So the Oklahoma Supreme Court in Muratori versus State in 2014 threw out the breath test as inadmissible hearsay. And that's a state-approved machine. Now, let's also look at something from Oklahoma. Again, there's many other states that have affirmed this as well. But here's something to look at. Oklahoma Supreme Court has affirmed that results from its field sobriety tests, such as HGN, horizontal gaze nystagmus, are not admissible as scientific evidence, creating a presumption of intoxication, but are admissible to establish probable cause for an arrest. Same thing as the PBTs, right? So my question is, why are officers still using and depending portable breath tests, number one? And number two, why are they hailed as scientific evidence? Why are SFSTs hailed as the gold standard for DUI enforcement? Why would I want to rely on something that's not even considered to be scientific evidence? Again, many courts, including Oklahoma, and Oklahoma has arguably one of the most conservative viewpoints of DUI investigations. They're the most beneficial to law enforcement officers. They even say it's not scientific evidence, but it's admissible to establish probable cause, right? And so this is what the case law, and the case law is showing this, and we have many more examples in the course that we talk about, but it's overwhelming. It is overwhelming, the amount of evidence and the amount of case law that's just kind of saying, no, this isn't science-based, and we affirm that it's not. And so I think that officers, sooner or later, are going to have to get better. And unfortunately, I think that that's probably going to be due to being forced to be better because of continuous case law that's affirming that SFST is just not cutting the mustard, and ultimately citizens being smarter. So here's an actual blood warrant case. This is a blood warrant DUI case that I did. This is mine. This is important because this was done, as you can see, last year, right? May of last year, 2024. And so just briefly, I responded to a call for service for a vehicle that almost hit a pedestrian. And so I heard that call. I put myself en route. Multiple calls came out saying, hey, this person almost hit this person. So I immediately was like, I got to find this car. I have multiple eyewitnesses that are saying this car is driving. So traffic was a little heavy. It was during the early afternoon hours. So I put my lights on and immediately started going to the area. As I started cresting a hill and going over, I observed the exact car that people were claiming was the car. Got it pulled over. Made contact. I observed, again, all the indicators of alcohol enforcement, right? DUI enforcement that you would readily see. Bloodshot, watery eyes, slurred speech, odor of alcoholic beverage. I had open containers of wine in the back, the little wine shooters. All of it, right? Wine-stained lips, right? Had it all. Everything I needed for DUI. You know what I didn't do? Did not ask her to perform standardized field sobriety test. Didn't need it. And I definitely did not ask her to blow. Didn't need it. I had all the indicators I needed and probable cause that I needed within talking to her for 10-15 seconds to make the arrest. So what do? I make the arrest, get a warrant for blood, get it approved and signed. I mean, 45 minutes for me to get the blood warrant signed. We go to the hospital, draw blood, continue on. Doesn't even go to court. When her defense attorney, saw that it was my name, saw that a blood warrant had been issued, they pled out. Now, this is important because as you're looking at this, we can see that her BAC was, according to blood analysis, 0.067. So the blood analysis, 0.067. So that's below the legal limit of alcohol, 0.08. So had I done a breath test, it would have shown that she was below the legal limit. What would the district attorney have done? They would have thrown the case out. Not only would they have thrown the case out, but you could arguably say that I violated her rights, right? That's an arguable statement. Well, what impairment do you have to a noticeable perceptive degree? Her BAC was below 0.08, officer. You could easily make that argument. There's no doubt. But when we do a blood analysis, what else do we see? Methamphetamines. We see THC. Hydroxy THC. THCA. Right? So we see other impairment. We see other drugs that would lead to impairment. Is this enough to get a DUI conviction? Absolutely. And here's the thing. We didn't get these results until later. She had already pled. She had pled out way before this evidence came back. And so I say this to say, and this is something that I used to teach, had I done standardized field sobriety test, may I have gotten indicators? Sure. But I may not have, right? Because SFSTs were not meant to be used for meth. They're not meant for THC. So there's a very good chance that she might be able to pass standardized field sobriety tests, because standardized field sobriety tests, according to the San Diego study, Florida study, and Colorado study, are not meant to test, are not meant to observe indications of methamphetamines or marijuana. But let's say she did give me clues of impairment, and I just utilized SFSTs in a breath test. Case would have been thrown out. So, again, this is a perfect example of I can get the results that I'm looking for, and I don't have to go through the ridiculous. I don't have to go through the ridiculous show of SFSTs. This is how I feel that it's just a show. And so again, this is a great example of how, utilize, and again, in the course we talk about all the science-based stuff, but there are science-based peer-reviewed studies that show indicators of impairment. Get your elements, write the warrant, get the blood, end of story. Because let's look back at this case. Is it possible that he had more than one beer in his system? Absolutely. Is it possible that he had other impairment, things of impairment in his system that weren't alcohol? Absolutely. So, why not get everything? Why limit yourself to one ridiculous test? Because I consider a breath test to be ridiculous. So why limit yourself to one test? I don't know. Law enforcement needs to be better. Anyway, hope this video was helpful for you guys. Most importantly, tell me what you think in the comment section below. I want to know what you guys think. Do you think SFSTs are outdated? Do you think breath tests are outdated? Do you think it's better to look at scientific-based indicators of impairment and then copy and paste a warrant template real quick and get blood? Tell me what you think in the comment section below. As always, guys, long live the Republic.